Hello, welcome everybody to the university seminar on global gun violence and health, part of the university seminar series at GW University, funded by the university on this topic of global gun violence and health. This installment brings together leading experts to discuss the effects of the U.S. legal regime on the global epidemic of gun violence and the resulting public health impacts across the world. We're going to start by looking at the Second Amendment jurisprudence of the U.S. Supreme Court and examine various legal issues that have given rise to the proliferation of guns within the United States and from the United States that are trafficked from the United States in ways that are affecting public health and well-being, not just in our country, but elsewhere in the region. Our goal today is to make the key legal debates in this area accessible to the general public as we explore the links between U.S. gun laws and the dire public health impacts of gun violence in the country and the region. My name is Arturo Carrillo. I'm your moderator. I am the director of the Civil and Human Rights Law Clinic at GW Law School, and I will be laying the foundation for today's discussion of the Supreme Court's Second Amendment jurisprudence before entering into a dialogue with our experts. Very excited to have these folks on the webinar with me. And we're going to talk about the legal regime, how it allows guns to proliferate, and then the impacts of that, as I just said. Let me take a moment now to introduce our panelists before we walk through the rest of the agenda. Very pleased to welcome Professor Jennifer Tucker, founding director of the Center for the Study of Guns in Society at Wesleyan University. She is also a commissioner on the Lancet Commission on Global Gun Violence and Health. Professor Tucker is a leading historian of firearms in the United States, and she will be discussing her research and the multiple ways that it shapes the evolution of law and public health in this country and around the world today. I'm also delighted to have a friend and colleague, Jonathan Lowy, president and founder of Global Action on Gun Violence, and a former legal director at Brady, where he litigated dozens of gun control cases for 25 years and filed amicus briefs to the Supreme Court for every major gun case during that time. He's going to help me outline the contours of the Second Amendment jurisprudence as it applies to gun laws in particular, and share with us some of his thinking on the topic. He's the author of an important law review article called The Right Not to Be Shot, Public Safety, Private Guns, and the Constellation of Constitutional Liberties. So those are our panelists. That's the short version of the intro, and they can talk a little bit more about the work that they do in the course of the webinar. This is our agenda. We're going to start off, as I've already said, by examining Second Amendment jurisprudence from the U.S. Supreme Court. We're going to then turn and think about what the impacts are of that jurisprudence in the U.S. and then extend that reflection to impacts outside the United States. And if time permits, at the end, we will have some Q&A. So moving right along, let's get started with the first point and allow me to give a brief overview of the Second Amendment jurisprudence evolution, and then we'll engage our panelists. So historically, the Supreme Court interpreted the Second Amendment as protecting the rights of people to guns for participation in state militias, not for self-defense or other private uses. Those are the early cases that you see on this slide. Then, in 2008, the Supreme Court, in the case of District of Columbia versus Heller, broke with this 200-year-old understanding of the Second Amendment as limited to well-regulated militias, and found that the Second Amendment provides, and I quote, law-abiding, responsible citizens, close quote, with the right to a handgun in the home for self-defense. This, in effect, created a private or individual constitutional right to bear arms under certain circumstances that could be used to strike down, and has been used to strike down or restrict gun control laws in this country. In 2010, the Supreme Court in McDonald versus City of Chicago held that the Second Amendment was applicable to the states through the operation of the 14th Amendment's Due Process Clause. What that means is that from that point forward, state laws seeking to regulate guns had to meet the same federal constitutional requirements as federal laws. And we're going to talk more about the implications of that finding very soon. Then in 2022, the landmark case of New York State Rifle and Pistol Association versus Bruin. In that case, the Supreme Court went further than Heller and struck down a century-old New York law that regulated the carrying of firearms in public spaces, declaring that gun laws like the public carry law at issue in Bruin were unconstitutional because they lacked sufficient historical precedent with respect to an individual's Second Amendment right to self-defense. In other words, firearm regulations today, after Heller and especially Bruin, must be consistent with the Second Amendment's text and historical understanding. And in the years since Bruin, several other legislative efforts at the federal level and others at the state level to regulate the possession and use of firearms have been struck down under this legal framework. A notable exception, I'll just highlight quickly before engaging John Lowy on this issue. A notable exception to this trend that I just described was a decision of the Supreme Court in United States versus Brahimi, where the court upheld a federal statute that prohibits persons subject to domestic violence restraining orders from possessing a firearm. That is, an individual person found by a court to pose a credible threat of to the physical safety of another person can be subject to gun control measures without violating their Second Amendment rights. So Rahimi is this outlier, or in a way, but in some, overall, the Supreme Court's line of cases anchored in Heller, and then particularly through Bruin, clearly give primacy to the justices, the majority of the justices, narrow interpretations of the Second Amendment, history and tradition, right, which is now that touchstone factor that needs to be taken into account when analyzing laws. And this significantly restricts the range of permissible efforts to regulate guns in this country. So that's the overview. Let me turn now to John and ask John, could you, as an expert in this field who's litigated many of these cases, expand a bit on this brief overview, and in particular, help us better understand what it signifies, what it means in context?
Sure, and your summary was excellent, Arturo. I mean, the way I see Second Amendment law, and I go back to before Heller, so I go through all of these stages of the Second Amendment. There have been essentially 3 chapters of Second Amendment jurisprudence, and the first chapter runs from 1791, when the Second Amendment was ratified, to 2008, so 217 years, where the Second Amendment was generally construed, in my view, correctly, as protecting the right of people to participate in state militias. And that really is what James Madison, who wrote the Second Amendment, and the other framers were concerned about. I mean, the Second Amendment was an anti-federalist. It was a request by the anti-federalists where they feared that the new federal government would monopolize military power and neuter state militias, which were very important to them. So that's what it was all about. Whatever the framers felt about private gun rights, that was not what they were concerned with when they drafted and ratified the Second Amendment. So during this period, the Second Amendment was really no impediment at all to gun control laws. However, something else was going on during this first period, which was sort of outside of the law. There was a campaign, largely driven by the National Rifle Association, to put forward that there was a private individual Second Amendment right to guns. A lot of this was done actually with marketing, cutting out the first half of the Second Amendment, which talks about a well-regulated militia, and just talk about the second half, a right to keep and bear arms shall not be infringed. And that was a very important effort, which I think helped lead us to the second chapter. The second chapter began with DC versus Heller in 2008, and that was a sharply divided 5-4 decision where the majority held that the Second Amendment does provide this private right to self-defense that did not have to have anything to do with militias whatsoever. again, I think that interpretation of the Second Amendment is completely unsupported by the text of the amendment, and also contrary to the historical meaning and intent of the Second Amendment. But one thing that Heller did not do is it did not announce any sort of test for courts to use in applying and interpreting the Second Amendment. And so what happened is lower courts, in fact, all of the circuit courts, evolved into into using this two-step test, where basically they would first decide, does this law affect Second Amendment rights in any way? And then if it does, step two was sort of a means test. It is the infringement on Second Amendment rights. How does that compare to the government interest? And it's the sort of test that you find in other areas of constitutional law. Then Chapter 3 is where we are now, and that began in 2022 with the Bruin case, where the court struck down a New York public carry law, but perhaps more importantly, replaced this two-part test to a history and tradition test, as you say. And I think it's important for us to consider how strange that history test is, because what that means is that public safety and government interests play absolutely no part in determining whether a gun law is constitutional. If under the Bruin test, if a law passed 100-0 in the Senate and unanimously in the House, and the National Rifle Association and everyone else agreed it was an important, great thing that would save thousands of lives, it still might be unconstitutional under Bruin, unless there was a sufficient historical analog. And there are a lot of reasons why there might not be a historical analog. For one thing, the law may be dealing with a problem that never came up before. And so it's a very bizarre test, in my view, and there's really no reason to be using it. Mm-hmm. Now, then what happened in Rahimi, which I think is part of Chapter 3, is the court said basically, we're still going to apply this history and tradition test, but we don't need the historical analog to be a dead ringer with the existing law. And what we're looking for instead is whether the challenge regulation is consistent with the principles that underpin our regulatory tradition. So you're looking at history, but the principles that you take from that history. And so it's a little bit of a broader lens. And, so then, where we're at now is still Bruin, but Bruin, somewhat refined by the Rahimi test. So courts still need to look to history and tradition.
Let me jump in there, John. That's really helpful. That fleshes out nicely the understanding of this framework, but it raises the next question, which is, how is this playing out in the lower courts, the ones that actually have to consider new gun regulations and laws, both from states and if Congress were ever to do that? How does this play out? Is it a functional test? Walk us through a bit the impact downstream of this jurisprudence as it's evolved over these stages.
Sure. Well, I mean, first, it's important to know that one of the reasons for this historical test, supposedly, was that it would bring consistency and objectivity to Second Amendment interpretation where judges would not simply be using their policy views, right? They would just look at history and history would provide the answer, and that would be the same answer for everyone, of course. Now, to me, that was definitely not going to work if you just looked at Heller and Brune themselves, because Heller, in the view of four justices and most historians, and I would agree with them, Heller got the history wrong about what the Second Amendment intended. Brune was applying this history and tradition test to public carry laws. Well, in my view, and the view of a lot of historians, if you actually applied the history and tradition test to the New York law that was challenged at Brune, you'd find that it was constitutional, because there's a very long tradition of restricting the carrying of firearms and other arms in public spaces. So those two cases seem to suggest that judges were actually, as I think it was Justice Scalia who said in another context, history was a place where you look for your friends. You look for history that supports what you want to do, and then you say that is what the history shows. And that's what we see. I mean, I think it's been sort of chaos since Brune, where you just have judges interpreting history in different ways, sometimes pretty clearly in line with their policy views, sometimes maybe not. But the fact is, judges aren't historians, neither are law clerks. So you have, like, the Fourth Circuit recently found that an assault weapon ban was constitutional under the Brune test. Then you had the Southern District of Illinois, a judge finding exactly the opposite view, applying the Brune test on assault weapon ban. On laws prohibiting possession of guns by felons, including nonviolent felons, you also have different results. You have the Third Circuit finding that someone who was convicted of fraud, a nonviolent offense, could not be barred from possessing a gun. This is under the Brune test. And then you have the First Circuit finding that the law prohibiting nonviolent felons from having guns was presumptively lawful. And so you're still finding this inconsistency and this fundamental problem, of course, where you have a test where you're asking lawyers who are judges and their clerks to be performing a task which they were never trained in, which is history.
Right. Well, we're very fortunate that we have a historian on this call that can help us better understand precisely that chaos that you've been describing, insofar at least as the role of history and tradition now in interpreting modern applications of the Second Amendment. And that's Dr. Tucker, Professor Tucker. Can you talk to us a little bit about what your role as a historian now is in this legal context, and how your experience as a historian of technology and firearms is coming into play in supporting courts as they grapple inexpertly, as John points out, with these issues?
Thank you, and it's really nice to be part of this conversation. As John was saying, the Supreme Court's 2022 Bruen case recast Second Amendment jurisprudence, so it means something different from what it did before. And courts are now turning to historians to help assess the constitutionality of gun prohibitions, asking such questions as, is a musket analogous to an AR-15? What did the founders think about body armor? What did they think about AR-style rifles on mass public transportation, like subways in DC? What about in bars and casinos in New Jersey? And it's also related to cases of sensitive places. What was analogous in the 18th century? Banks, casinos, national parks, sports arenas, schools, courthouses, libraries, and medical facilities. So these aren't the kind of questions that as historians, we are, that we generally ask. In fact, they're pretty outrageous questions for historians. I mean, as a matter of history, because we are trained to study, context, and also to look at change over time. But this kind of mangling of history and disregard of some of the policy concerns that John was referring to is what the new new doctrine of originalism seems to require. And in terms of the some of this history is getting published in law review journals, which are also by lawyers, rather than necessarily historians. But whatever, I would just say, whatever people think about whether or not this is a good way to do policy or history, that is the state of affairs right now. That is where the Bruin decision left us.
So just following up on that, it's looking at the examples you gave, a sort of implied issue there is the way that technology evolves and the need to come up with analogies. That seems to be at the very heart of how this framework is implemented or not, effectively, or honestly. And so can you talk to us a little bit about the struggles that the Supreme Court and other courts have had in relation to this issue of technology and its evolution, and the way that it complicates the analysis, even under the Bruin framework? That would be really helpful.
Sure. Yeah. And I should have said at the top too, that as a historian, I'm really interested in digging into these early gun laws. So I'm really taking Justice Thomas in that, in that decision seriously, that we ought to know more about what these early gun laws are. And when we start digging into them, we see that across the patchwork of the nation, there were lots of regulations. I mean, because there were many communities that wanted to make communities safer, even for all these years where the Second Amendment applied. So in terms of technological change, the current legal discussion about the Second Amendment really says little about technology, although the phrase dangerous weapons comes up a lot. A gun is a gun is a gun, whether it's a colonial musket or an AR-15 rifle. We talk about bullets like they're all the same. There was a positive sign, I think, last week or 2 weeks ago when the Supreme Court made its ruling in the ghost gun, the privately manufactured firearms case, where they were starting to, they were taking a look at that. If I can just have the next slide. So I think this is a question, is there room for looking at the lethality of modern firearms when considering the constitutionality of regulation? The Supreme Court implicitly acknowledged this in Heller when it stated that machine gun bans were acceptable, even though automatic weapons, grenades, and landmines would be necessary to launch modern militia force. And so it is a difficult concession to explain unless the court is considering or open to considering the modern capabilities of firearms outside of the historical scope of regulation. And if I can just have the next slide, please. Okay, so here we're looking at different types of arms from different eras, early cannons from the 13th century, the 15th century, and then the Kalashnikov AK-47 fully automatic rifle on the bottom right, and the Springfield AR-15 semi-automatic rifle. So, hand grenades and machine guns are still considered dangerous and unusual weapons for the purpose of the Second Amendment. And if we can go to the next slide, there are some key technological developments that have increased the lethality of firearms dramatically since the era of the founding. And for anyone who's handled historical firearms, these differences may be apparent. During the 1960s, a military study was undertaken to try to measure the effectiveness or lethality of weapons as a function of their ability to harm the enemy. And the author of it was a U.S. Army military historian, Colonel Trevor Dupuy, who is still arguably probably the country's leading military historian of the 20th century. And what he was interested in was taking into account different factors such as range, accuracy, rate of fire, reliability, durability. And then also one of the things that the study found was that there was an exponential increase in the lethality of firearms between the 1840s and the 1880s after the Second Amendment was written, and that there was a tenfold increase in the lethality of individual firearms then, and then additional increases in the 20th century, making the modern automatic rifle 100 times more lethal than a flintlock musket. And we could also get into, if we want to, in the Q&A, to talk about how the lethality of bullets has dramatically increased in the 20th century as well, and even since the 1980s. And if we can go to the next slide. So just some important things to think about when we're talking about firearms. We talk a lot about gun owners and people who don't own guns, and sometimes the discussion about the product itself is missing. On this slide is a photograph of an exhibit at the NRA's National Sporting Arms Museum in Springfield, Missouri, which is called 21 Gun Salute. And it's a photograph showing it's a display of long arms used by U.S. soldiers from the 18th century from the left to the 21st century on the right. I think the current discussion we have about technology uses a kind of single logic approach, that guns just kind of generationally, unfold according to natural laws, from the brown bess to the modern rifle. But that's a very reductionist way to talk about technology today. And the founders, when they, were writing when they were drafting the Constitution and thinking about the future of the Republic, they could have been forgiven for thinking that a gun is a gun is a gun, because the basic flintlock really hadn't changed that much in the previous 150 years. But and I think if the Constitution had been written, in the 1880s instead of the 1780s, they would have been much more aware of the pace of innovation. I'll just stop there.
Well, I do think it'd be interesting to expand a little bit on the munitions aspect of it, because a musket ball, and projectiles for several, decades or centuries after that don't change, but that's not the case anymore. There are some, and you look at some of the gun massacres that have been carried out using, munitions that aren't designed to wreak havoc on human bodies. It might be worth a word now on that, and then I'm gonna have John react from a lawyer's perspective to this excellent overview of the role of lethality as the technology, right, in the way it evolves in guns. Sorry, go ahead.
Yeah. So this is there was a study by Anthony Braga in Boston, which showed that in the homicides there, that if a lower caliber bullet had been used, there would have been a decrease in the amount of homicide. The bullets, the lethality of bullets dramatically increased in the 20th century. And some of the studies that have been done on lethality of bullets has been done by emergency room surgeons, who found that trying to take bullets out of gunshot victims, that the new the hollow bullets were cutting the hands of nurses and doctors. So it's another it's another dimension of this issue. But again, talking about arms, also to think about the ways in which bullets also are designed in a ways to increase their lethality. And if we want to study their functionality and the impact that they make on bodies, we should be talking about the energy that's released by them when they enter the body, the kind of cavitation that creates, the difference that, nobody survived in Sandy Hook, because also the children's organs are packed together. Older people, people who are more in middle age, the organs are farther apart. So there are these impacts on the body of the combination that we need to talk more about that.
Yeah, and presumably the Supreme Court and the other courts that interpret this history and tradition standard would need to find a way to take into account these technological advances and in lethality, not just of the firearms, but the munitions as well. And that seems to be the conundrum, if I understand you correctly. Well, let's hear from John again. As a lawyer who litigates these cases, what would it take to get courts to look at these dimensions that are so critical to the modern use of guns and have that somehow play a role in their analysis? It just seems mind-boggling that they wouldn't.
Well, I think one important factor to remind ourselves of is that the right that was recognized by the court in Heller was a right to self-defense in the home. Okay. And then in Brune, to some degree, it was expanded outside of the home into public spaces. But if the core of the right, as the court has said, is a right to, defend yourself, then the courts should be looking at, well, how do individuals, in the home, if someone busts down the door, let's say, or they're walking down the street and they're under attack, what do people use to defend themselves? People who use guns. And, it's not AR-15s. It's not AK-47s. It's, pistols, conventional pistols for the most part. In the home, it could be a conventional rifle or shotgun. And, so a lot of the most sort of destructive technologies are either unnecessary for, individual self-defense, or in some cases, exactly what you don't want, because they'll, might shoot through, the wall of your apartment into the next apartment. And also, I think courts, should consider facts like, how do people actually use their guns in self-defense? It's usually actually brandishing it. And then, beyond brandishing, maybe firing, one shot. It's not firing 10, 20, 30 shots. That just doesn't happen in reality unless you are, repelling, a zombie invasion. So, given that, in my view, assault weapon bans, high capacity magazine bans, and a lot of other, destructive technologies, should not be constitutionally protected under, the Heller ruling itself.
That's really interesting. So it would need to be taken into account in understanding what self-defense means, and the arguments for or against would, yeah, that would be the way to address that. Thank you, John. That's great. I want to pivot a bit here and broaden our horizon outside of the boundaries of the United States and start thinking regionally and globally about what it means to have a country with more guns than people, and that has the ease of access to firearms that the United States has, and what that means. John, not long ago, you appeared in an episode of 60 Minutes entitled The Iron River. You did a great job, by the way. And in that episode, the focus was the extent to which firearms trafficking from the United States, where, as I noted, guns are plentiful and easy to access and buy, they're trafficked from the US to Mexico, where guns are highly regulated, difficult to buy legally or possess legally, and that this is generating a crisis of violence and criminality in Mexico. Some estimates, you'll correct me, range between 200 and 500,000 guns a year trafficked across the border into Mexico from the US. There are statistics that suggest that somewhere between 50 and 70% of crime guns recovered in Mexico have an origin in the United States. So they were trafficked into Mexico and then used in criminal acts. So severe, right, this crisis of public safety, that Mexico has decided to sue the US gun manufacturers for complicity with that situation. And you are counsel to Mexico in that case. Can you talk to us a little bit about the impacts in Mexico? And it's not just Mexico, but this is where the case that you litigate came from. What does that look like? What's going on in terms of the trafficking of weapons and the impact, and why drove a country to sue manufacturers in a different country, an unprecedented act from a legal perspective? Talk to us about what's going on there.
Sure. Well, I mean, we're all aware of the huge gun violence and crime problem in Mexico. President Trump recently designated certain Mexican cartels as transnational terrorist organizations. And, those criminal organizations are armed almost entirely from US guns. These are guns that are trafficked from the United States into Mexico. And it's actually the same way that guns are trafficked from the US to the gangs in Haiti and Jamaica. And the way this works is you have a small percentage of gun dealers in the United States that sell virtually all of the crime guns. And that's true for how the US crime gun market is supplied, as well as Mexico and other countries. ATF found over 20 years ago that about 90% of gun dealers sell zero crime guns. Yet about 5% of gun dealers sell about 90% of the crime guns. So, you've got an industry that, at least at the retail level, is largely, very law-abiding, careful, but you've got these bad actors, as you do in every profession, but in the gun business, they can do a tremendous amount of damage. And, these bad actors, these gun dealers are selling guns to obvious gun traffickers and straw purchasers who are buying guns for someone else. And you see these patterns where the cartels will send a trafficker to a gun store. He may buy 3 assault rifles or 5. He may buy hundreds of rounds of ammunition, maybe all in cash. And then he comes back, a week or 2 later, 3 weeks later, buys more, comes back again, buys more. Sometimes he'll buy a 50 caliber sniper rifle, which is a gun that can shoot down helicopters. It's a true military weapon. And all of these things are red flags that for the 90% of gun dealers that are law abiding, they would turn that purchaser down. They would call up law enforcement and say, you should take a look at this guy. I think it's a trafficker, but the bad actors are happy to make the money. And then manufacturers, for their point, they know and have known for over 20 years that this is how the crime gun market is being supplied, through these bad actors. Manufacturers have been told to stop supplying these bad actors. They've been told to have standards of safe sales practices, require training for your downstream dealers, and they've refused because they want to profit off of this criminal market, including the criminal market to the Mexican cartels. And that's what Mexico's lawsuits are aimed at. There's one lawsuit that's aimed at manufacturers, and another is aimed at gun dealers in Arizona. And the basic argument is that both the manufacturers and the dealers are either directly illegally selling guns or aiding and abetting the illegal sale of guns that they know are supplying criminals and supplying the cartels in Mexico. And in my view, the only effective way to stop this crime gun pipeline is at its source, and that's the gun industry. If you just go after the traffickers themselves and the straw buyers themselves, you're playing whack-a-mole. There's going to be another trafficker. There's going to be another straw buyer. But if you go after the manufacturers and simply get them to sell guns in a safe, responsible way, and get the dealers to sell in a safe, responsible way, you will stop the flow of crime guns to Mexico, but also to communities throughout the U.S.
So the concern of the Mexican government in bringing this case is the impact or the effects of those guns in the hands of the cartels on the other side of the border, the criminality, the killings, the violence, which takes place as a result of having well-armed drug cartels running rampant. Is that right?
Yeah, that's exactly right. And of course, the U.S. suffers great damage as well as Mexico. The fentanyl trafficking, in the U.S., opioid overdoses from fentanyl in the U.S. I mean, that comes from Mexican cartels, which they could not do if they didn't have US guns. A lot of the migration comes from violence in Mexico from US guns. The cartels themselves are spreading their reach throughout the US into Canada as well. None of this would be possible, without US guns. Now there is, maybe we don't have time for it, but there's a complicating factor to the Mexico lawsuits, which is that the gun industry has won a number of special protections from Congress, and one of them is the Protection of Lawful Commerce and Arms Act, which gives gun companies special protection from civil liability that no other industry in America has. And the Supreme Court just considered an argument in Mexico's manufacturer lawsuit just a few weeks ago about whether that federal gun industry protection law prohibits liability in Mexico's case. And we'll find out most likely in June what the Supreme Court rules.
That's exactly where I wanted to go quickly. Just before returning to speak with Professor Tucker, I wanted to ask, did you, at the Supreme Court argument, sense that there was any concern about the effects in Mexico, the extreme criminality and violence that the arms enable, right? Was there any concern about the devastation or the havoc being, occurring across the border as a result of, the issues in this country with regulation, the human part of it? Did you sense that came into play at all in the argument?
I mean, we'll see what the court does. I mean, I did think that the justices, for the most part, took the case very seriously, and they certainly seem to recognize that this was a major problem and the gun industry's conduct. I mean, Chief Justice Roberts said at some point to the gun industry lawyer, basically, he said, at some point, manufacturers would be deemed the proximate cause of some of this harm in Mexico. The only question is, what rules do we make for liability? At what's the threshold that Mexico has to prove? So they did take the claim seriously, but sort of just like we were talking about the Second Amendment, how like policy and public safety no longer has a place for the most part in Second Amendment jurisprudence, which is sort of crazy. Because of this special protection law, the PLCAA, public safety and policy don't have much of a place there either. I mean, the question is really, has Congress prohibited this sort of liability? And if it has, then there can't be liability, no matter how dangerous, reckless, and awful the conduct of the industry is. And that's really the issue that the court's going to decide.
Thank you. Yes, and that, I think, sets up nicely a reflection on the global implications of the Second Amendment and the legal regime in this country. And in that regard, I want to turn back to Professor Tucker and ask a question about American exceptionalism in terms of the Second Amendment. So just to tee it up a bit, as you well know, our colleague Phil Alpers through the gunpolicy.org website did a comparative law research across almost 160 countries in the world, and was able to tabulate some high-level indicators that suggest, first, that 97% of those countries studied do not possess a legal right to own a firearm, much less a fundamental constitutional right. Of those countries studied, nearly 160, 98% had some form of mandatory licensing requirements for purchasing guns and possessing them. Another 98% had requirements to register firearms, to keep track and monitor firearms in circulation. None of those things exist as mandatory requirements in the U.S., except for, of course, the Second Amendment right to bear arms in the terms that we've been discussing. In that context, how are we to understand American exceptionalism in relation to the Second Amendment and the way it enables the proliferation of guns and gun violence? What can we learn from what is going on in other countries in ways even broader than what we just talked about in relation to Mexico?
Yeah, well, as you said, other countries have adopted three pillars of gun regulation: licensing gun owners, registering firearms, treating private gun ownership as a conditional privilege rather than as a right. And the U.S. is an outlier in opposing those basic pillars. Another way in which, even though actually in other areas of life, such as in registering car vehicles and driving, though it is recognized that that the rules of the road should risk losing that right. There's another way in which the United States is exceptional, though, and that is, and it comes back to something that John was saying earlier, and that is the distinctive role of the United States in firearms manufacturing. There's a common narrative in American society about guns being used for hunting and self-defense, and that's there. But for the past 200 years, the major driver for innovation in firearm design has been the military. It was not for hunting or self-defense. However, people are using them. That was not the end. And guns are dual-use technology, and the same firearms that are used in the military, they spill over. We have a spillover effect, and we're used to thinking about, spillover. A lot of times, things invented by the military spill over to the civilian. Duct tape, Teflon, cargo pants, microwaves, internet, etc. We can decide whether or not cargo pants are a benign or a malign invention of the military to give us. But with the firearm, we're getting something that is really having in the way it's been used, disastrous consequences in U.S. history and across the political divide. And there is broad support for the idea that, lots of people, including in the gun industry, do not want to see civilians using tactical nuclear weapons or hand grenades, or like, what is the upper limit actually to all of this? So, and in terms of what we can learn from other countries, I mean, this research is ongoing to learn from other countries on how they, how they adopt these pillars. But I think the focus on, what we can all do together to talk about what amount of lethality is an acceptable burden of risk for the rest of us is a good one. I also want to just mention here, as a historian, I feel like I should say that we're not the first generation to think about ways to try to reduce gun deaths or and its effects economically, people taking care of people with gunshot victims and so on. There's the first National Commission on the Causes and Prevention of Violence took place in 1968 in the wake of assassinations of Medgar Evers and Martin Luther King and the Kennedys and lots of other factors. And what they did was produce hundreds of documents that they collected. This was on how other countries, what their historical and comparative gun laws were from 187 countries. And there's hundreds of documents from that. And it had broad bipartisan support. In fact, it was steered by Dwight D. Eisenhower, whose brother was very, very concerned on it. So I think that there's an opportunity to really build on these earlier efforts. And, maybe that's just where I would leave it.
Okay, thank you. I think I'm going to turn to a question from the audience, just to sort of bring a concrete example in. And one of our audience members asks, is it possible to get a law passed that all guns can come with a lock or a lock safe, that you must buy them together? Or is there a way we can encourage gun manufacturers to provide gun safes and gun locks, or maybe even require them to do that? John, maybe get us started. What do you think?
Yeah, I mean, well, I'd go a little beyond that. I mean, gun manufacturers agreed a number of years ago under the Clinton administration to ship new guns with a lock in the box. A number of manufacturers agreed to do that. But, I think we need to do more. I mean, if you use like the analogy to cars, of course we had first we didn't have seatbelts and people installed them if they wanted them. Then we had mandated seatbelts, then we had airbags. I mean, with guns, we could do something similar. I mean, one thing, it's very easy for gun manufacturers to build in a lock in the gun itself. And there have been major manufacturers who've done that, but then they have not continued to or use them widely. And that's much better than having a lock, because it's much easier to use, and it also can't be separated from the gun. Then beyond that, we could have what's called smart gun technology, which is more like an airbag. If you can open your iPhone with your thumbprint, you can have something similar with a gun. And there's been types of inventions like that for decades, and there are some that now are really at the feasibility standpoint. One problem with guns, like with the special protections that the industry has, is that since the Consumer Product Safety Act was enacted during the Nixon administration, there's been an exception for guns. So guns are the only consumer product that has no federal product safety oversight. And
Right.
as a result of that, there can't be a mandate under current law to require these sorts of safety features, though it can be voluntary. I mean, we should be repealing that special exception and have guns, regulated for safety, just for the sake of gun owners and their families as much as anyone else. And then we could get some of these effective technologies in place.
Yeah, no, that's really helpful. If I were going to adapt this question for you, Jennifer, I would ask, and this may not be a fair question, so if it's not, you should definitely protest. But let's assume for a minute that a law requiring guns to come with locks is passed. Would it survive a Bruin analysis under the history and tradition test?
Well, again, so then what you would do is find out what was analogous in the 18th
Right.
century. Yeah, I mean, in the 18th century, there were, there actually some of the strongest voices for safety in firearms has come from the military. So to the extent that there have been safety devices, it's been to protect soldiers. So yeah, you could certainly look at that. In fact, one of the things I'm very interested in work on is the history of gun patents. So don't get me started going down that wormhole, but I think that's a very interesting, historical question, where the patents, and maybe to this point, actually there have been firearm companies, industries historically who did try to integrate electronic, identification mechanisms into the firearm, even in the 90s, too prominently, and where they ran into problems was in the state legislatures or with politicians. So, I'll just mention that as an example that, I mean, but as I think John has said very, very rightly, that there are a lot of barriers to change that
Yep.
need to be looked at.
Yeah, no, that's helpful. If I remember correctly, you'll correct me. I mean, gun locks are like a 19th century technology, right? I mean, it was something that was designed very early on and just ignored by the industry or rejected by the industry. Just to give credence to your instinct that there are precedents in history tradition that might actually support something like guns should come with locks in the way that cars should come with seatbelts.
I think
right?
with the new laws, it goes back to the original slide showing the change and the understanding of what the Second Amendment means since 2008, means that with the rise of things like stand your ground laws, there will be some people who will want to have gun locks and safe storage, but then, the laws have facilitated the rise of an idea that, it's better to have access to any firearm at all, even if it doesn't match your personal ID. So it's complicated.
Yeah, it's complicated, definitely. Well, I think, to start wrapping up, I want to do, unless there are other questions that come into the Q&A, I want to do kind of a closing round of questions for each of you, or it's a version of the same question. I'll start with John, and it's really geared to looking ahead. What can we do moving forward, given the lay of the land legally that we've discussed, given the global reach and impact of the legal framework in the U.S. And the negative impacts on public health, not just in the U.S. but abroad. John, the Supreme Court is currently locked in a kind of 6-3 configuration. Very much behind the Bruin line of interpretation. So, what do you see are the possibilities moving forward for change? What is it we should be focusing on, given that scenario?
Well, I mean, for one, I think even with Heller, Brune, Rahimi, there's a lot of laws. I think most of the sort of gun violence prevention agenda would be constitutional or should be. And Jennifer mentioned the 3 pillars. I think the first 2, licensing, registration, in my view, would be constitutional. I mean, in fact, the militia, there was registration with the militia. So even where there is a right, there can still be, significant regulation. But then, as far as what can we do with the Supreme Court jurisprudence, I think one thing that one promising argument and strategy is that even where there is, according to the court, this private right to arms, there are also competing rights that are affected by that right. And, I wrote an article almost 10 years ago called The Right Not to Be Shot, which talked about the fact that even though under Heller, there's a right to guns, which I said is really a right to shoot. It's a right to use guns, that is to fire them. There also is a countervailing right of people not to be shot, a right to live, to public safety, and that virtually every constitutional right has been cabined, restricted by the Supreme Court in some way to protect public safety. You have a right to property, but you don't have a right to public nuisance. Police are restricted in all. Everyone is restricted in some sorts of ways. I mean, you have a right to speak, but you don't have a right to shout fire in a crowded theater because of the threat that people might get trampled. That's a right to public safety. A right to live. And so I think going at it that way and talking about these other rights to assembly, to free exercise, religion, speech, etc.,
education,
the court can, and that is a way that the court can say, okay, we're not limiting this, what we view as the Second Amendment right to arms. However, it doesn't, so to speak, if we can still say it, trump all of the other rights.
Countervailing fundamental rights. I like that.
Exactly.
Okay, Jennifer, you're going to have the last word today. What are your thoughts on what lies ahead and what we should be focusing on?
Technology. I'm biased as a historian of technology, but I think we need to talk more about firearms, rifles, revolvers, pistols, more in terms of their functionality, their purpose, and what they do to the body. Different firearm bullet combinations, and part of that means reframing the conversation around not just binarism, gun owners, non-gun owners, but or just freedom and rights, but also talking about costs, not only medical costs, but economic costs and responsibilities. And I think about how when we're in an airplane, and they ask us to put our bags of peanuts away because someone has an allergy, we do it. Often we should do it, and how can we think about, I just think a lot of people think this way, and that, we can do better on this issue, and we can do it in a bipartisan way. I'm very hopeful that we can do that. Well,
thank you. That is a perfect way to conclude this webinar. I want to thank everybody who joined us, and especially the panelists, John, Lowy, Jennifer Tucker. Thank you both. It's been very enlightening, and I wish you and everyone who joined us today a wonderful afternoon. Thank you all.
Yeah.
Thank you.